circumstances of this case, we are relying on the first part, the use of force, which was witnessed during the so-called rearrest of the accused persons before you. There was force used to get them from the courts and now to present them before this court. Your Honor, we have gone, the definition, I believe my learned friend from the LSA, our DP, Maura Kabata, defined to the court how an arrest should be conducted and pursuant to a reasonable apprehension that an offense has been committed. All that is on record. The point that requires emphasis is that the accused persons had been, let's assume it, they had been lawfully arrested. They had been lawfully arrested, but in the course of processing bail pursuant to court orders, they were grabbed from the registry while processing bail. Clearly, this was done not pursuant to any apprehension, but to defeat the orders that had been made by your learned colleagues. You can say there is nothing technical that can be able to enable any person using common sense and blessed with reasons by the Almighty God to interpret it any other way. That you are grabbed from the court registry to defeat the orders of the court setting them free on board. In the case of Bennett versus the Horseferry Road's Magistrates Court, right? The issue was precisely that if you ought to have brought Bennett from South Africa pursuant to an extradition order, and that order was not there, the court actually said, we cannot allow people to be tried in English courts. People who have actually been abducted. Actually, the truth of the matter in Bennett's case, the discharge was on the basis that he was abducted. In the context of this case, and the law has always meant the Constitution, the statute, promulgated rules and regulations, and judicial decisions of the court, and judicial orders. There was a judicial order setting them free. Over the same facts, the prosecution, I was waiting for that. The prosecution, I concede, if these two accused persons had committed terrorism act in Canberra, and Garissa, where this terrorism is actually perpetrated, it would have been a different ballgame. But it was the same offenses, the same set of facts. That the courts had said that there is no basis why your rights under Article 49 should be derogated, because that was the issue. Whether the DPP and the police justify the derogation of fundamental rights. Those magistrates say there were no grounds for derogating their rights and to ensure that they were further detained. Accordingly, any attempt to arraign them before you in disobedience of court orders and to defeat the proper administration of justice cannot be countenanced under the principle laid out in Hospital versus Magistrate and in the Gedongori case, because it was the same case, abuse of power. Abuse of power cannot be countenanced, cannot be tolerated. Your Honor, the issue, you are told that there were no charges that were facing them. But you would read all the affidavit. And that is a specific argument that was made both in Kiambu and Roiro, where I was there myself. They said, we are holding these people on the basis of specified offenses. Mr. Maura Kapata had read you. Robbery with violence, arson, all these kinds of things that are being cited today. And the issue for purposes of Article 49 of the Constitution is not the charge sheet, which is a legal document. It is, what are the offenses against this man and woman? The offenses were set out in an affidavit. So when today you are told we have a charge sheet specifying a terrorism act, this is a fiction used to justify disobedience of the law and to justify abuse of power. Because if it is permitted to proceed as such, and that is a bigger question, the courts would effectively have lost control over the persons brought before it for purposes of any prosecution. Your Honor, you are referred to certain provisions of the law. There is this issue that has repeatedly, you've been told, oh, we are seeking judicial review of the decision to charge that has been made by the DPP. There is no doubt that the DPP can make decisions to charge. But you must be satisfied that you have jurisdiction. Jurisdiction can be complex. Europe, where Devil Zero was killed, it clearly cannot, you cannot say that you have a valid charge. Let us wait for the DPP and the police to give us evidence. You know, this is a mischief rule. The court must go to the mischief rule. The last 2 points on the Constitution is this. About your authority, that 1 and 4 of the Constitution. Under 21 and 4 of the Constitution, issue of application of the Bill of Rights. 21 says the Bill of Rights apply to all and binds all state organs and all persons. Your Honor, you are a state officer. To observe it. But more importantly, 20 sub-article 4 is very clear. In interpreting the Bill of Rights, a court, a tribunal, or other. Article 23 of the Constitution. Article 23 of the Constitution shall enact legislations to give original jurisdiction in appropriate cases to subordinate courts to hear and determine applications for redress of a denial, violation, or a threat to a fundamental rights in the Bill of Rights exercised directly It doesn't require any law. So you apply that authority as you understand it. So we are perfectly entitled to say it's across, not just in Kenya. A person who are hated, who are...
Your Honor, we have to bring this to its useful conclusion. We thank you.